As for introduction, most legal charities have charitable trusts. These organizations have a board of trustees that oversees the trust income and capital. As registered charities and tax-exempt trusts, charitable trusts must use their funds for charitable purposes. The statute in Malaysia is Charitable Trust Ordinance 1994, but the law of Sarawak repeals and replaces it with Charitable Trust Ordinance Chapter 102 of 1958. This Act provides better provision for the creation, administration, and management of charitable trusts. Settlers rule, trusts hold money, investment, or property for various reasons. Trusts, including testamentary, living, revocable, and irrevocable trusts, give asset protection choices. Trusts help ensure the settler assets are used as intended, save probate fees, and cut estate taxes. They can also speed up the transfer of assets after the settler's death. A trust can help parents ensure their children don't waste their inheritance. Trusts allow the trust creator to decide, when they have full mental capacity, what will happen to their assets if they become mentally impaired or unable to make decisions. This idea is a private express trust for ascertained or least ascertainable beneficiaries. The settler must settle the property on trust for individual benefit or company advantage that are analogous, so the trustees can understand who will use the trust. Nonetheless, charitable trust is one of the exceptions to the beneficiary principle, as there must be charitable purposes under Section 3 Clause 1 of the Charitable Act 2011 of United Kingdom, which include that a purpose falls within the subsection if it falls within any of the following description of purpose.
Although the current rule is already fair in equity and working fine within its application, there are still some issues that may arise from the personal nexus rule in charitable trusts. So the first issue that may arise is on the matter of discrimination or not allowing the charitable trust to aid a specific community alone. So the Compton case from 1945 is a case that states there must be enough benefit for a larger community for a trust to be considered charitable. Hence, it does not allow charitable trusts to aid a specific group. However, this could be argued with the precedent from the Dingle and Turner case from 1972, where it was held that one does not necessarily need to cater to the larger community for a charitable aid. Now, the charitable trust that was set up for the E. Dingle Company staff was said to be charitable trust by the courts, as it catered to over 600 staffs under the company. The second issue that may seem to affect the rule is the limited definition for charities within the Charities Act 2006. Now, the current definition for charity is said to be activities that alleviate or reduce poverty. However, this may become a problem as charities are not necessarily dedicated to reduce poverty alone, but also to aid in other matters such as education or healthcare. Now, the Hope and Arrow case was a case in which it was stated that funds may be used only for public benefit and must relieve poverty. Now, this view may be problematic for the reason that it does not include other forms of relief to be considered as charitable. Now, this has been evident in cases such as Baldry and Fine-Tuck from 1972, where a student union couldn't be considered a charitable unit if it were to have partisan ideas or to push agendas against governments. Now, while this case itself doesn't necessarily mean that educational charities cannot exist, it does, however, enforce that these educational charities cannot preach specific ideologies.
So, we move to the implication of personal nexus test. The implication of this test is it will determine the validity of the charitable trust, because this test is one of the criteria to fulfill one of the elements of the charitable trust, which is public benefit. So, in order for the settlor to establish this element, the settlor must fulfill the requirement of this test, which is there must be no connection between the settlor and the beneficiary. The implication of personal nexus test to settlor's rule can be illustrated in the case of Oppenheim versus Tobacco Securities Trust Co Ltd, where in this case the income was to be used towards the education of the children of current or past employees of the company or any of its subsidiaries or affiliated companies. The number of people who could benefit was estimated to be the millions. The question of whether the trust was legal arose in these circumstances. Lord Simmons stated that the nature of the purpose, which was to enhance education, was good. However, the employment nexus that linked the trust direct beneficiaries or their parents made it private rather than public, on the grounds that the beneficiaries did not represent a large enough segment of the public.
So the next case that is related to the personal nexus is the case of IRC against Educational Grants Association Limited. In this case, the objects of a charitable company were the advancements of education. Its income was derived principally from a single company, and between 75% and 85% of expenditure was applied for the education of children of the employees of the company itself. It would not have been possible to create a charitable trust for the education solely of children of employees of the company. In this case, it was held by the court that the income applied for the education of children of employees of the company did not qualify for exemption from income tax because it was not applied for charitable purposes only. Charitable trustees must consider the whole of the class that may benefit from their charity's purpose if they are to properly exercise their discretion in choosing which beneficiaries will actually benefit. So in this case, there is a nexus between the settler and the beneficiaries in which the trust will be regarded as a private trust and cannot be countable as a charitable trust, and thus the private trust cannot be exempted from income tax, and the respondent need to pay tax as usual. So there is another case that is related, which is the case of Rehoboam Aero Components Limited's Air Raid Distress Fund. In this case, the trust sought charitable exemption for sums collected voluntarily from workers in a munitions factory for the benefits of co-workers who had suffered in the blitz. Lord Green, in his statement, states that a number of employees of this company, actuated by motives of self-help, agreed to a deduction from their wages to constitute a fund to be applied for their own benefits without any question of poverty coming into it. Such an arrangement seems to stem the whole transaction as one having a personal character. Money put up by a number of people, not for the general benefits, but for their own individual benefits. The people who are eligible to receive benefits were not even all the employees of the particular company. They were those who chose to join in the scheme. Hence, in this case, the judge had found that the trust not to be a charitable one. The trust in this case only benefit a sum of people in the company, and only that people has an access to receive the benefits. Therefore, it seems that there is some sort of personal interest between a few people in the company, in which it shows that there is a personal nexus in the trust, as it does not benefit the people in the company as a whole.
Poverty rule is an exception to the settler nexus rule. In the 19th century, the Court of Chancery was of a practice that express trust for poor relations were declared as charitable trusts. The reason was that it is beneficial to the public in a sense that it lifts up financial burden among the community. In Isaac versus DeFries, the exception to the nexus rule was applied in referral to the practice at that time. Later on, in the case of Recompton, the court ruled that the trust was not a valid charitable trust when considering whether or not it was charitable. In this case, it was the beneficiary's relationship with the testatrix that served as a specific person, which, according to the personal nexus rule, the trust shall not be charitable. Furthermore, a gift intended to assist some particular family members is treated differently from a gift intended to benefit the entire community because it is considered as a family trust. However, in Rees-Carris-Brick, Principle to Poor Relations Trust was established. The beneficiaries have relationship with the donor, but was allowed as charity since the aim of trust was made to relieve poverty. In Rees-Siegelman, it has been laid down that a gift of poverty is no less than charity. In the recent case of the Tuan Khana and Company vs. Salim bin Lau B. Chiang and others, in other appeals, the court found that the aspect of public interest is not fulfilled. It cannot be considered as a charitable trust due to the description of a specific group of people, which is in this case their direct descendants. Therefore, the rule of personal nexus was applied. To conclude, the non-exception to the personal nexus rule is uncertain and often lead to arbitrarious decision. This is because the definition of public and community is too vague and broad. In addition to it, the standard rule of charitable trust can sometimes be looked as a discrimination towards a certain group of people, although it satisfies the public aspect of public benefit test. However, it is duly accepted that the law of equity changes from time to time. Lord Wilberforce in the Scottish Burial Reform and Cremation Society and Glasgow City Corporation's case was of a principle that the rule of charity is a moving issue that evolves with time. According to Lord Simmons in National Anti-Vivisection Society and Inland Revenue Commissioners, a purpose considered as charitable trust in one century could be viewed differently in another.
As for conclusion, as the settler can declare an immediate trust over the state property due to no formalities required for a legitimate declaration of trust over personal property, there will be statutory procedures to complete for the subject of trust to land and to other specific property before a valid trust is made. A living trust is created and effective for the settler's lifetime. A testamentary trust is created by a person's will and takes effect after their death. These two approaches may have varying requirements and fees for forming and amending a trust. Some distinction may be relevant depending on the aims being pursued.